Good afternoon. I'm going to inform you all that we are currently being live streamed on OTA's live stream. My name is Judge Long, and welcome to the Office of Tax Appeals. Due to unforeseen circumstances, Judge Vasig is unable to attend today, and I will instead be your lead judge for purposes of this hearing. This hearing is being auto-transcribed. To ensure we have an accurate record, we ask that each person speaks one at a time and to avoid speaking over one another. Also, we ask each party to please speak clearly and loudly, and when needed, I or another panel member will interject to ensure we have proper transcription. After the hearing, OTA will produce the official hearing transcript, which will be available on the OTA website. As a reminder, the OTA is not a court, but is an independent appeals body which is staffed by subject matter experts and is independent of any tax agency. While OTA is not a court, we must nevertheless follow certain guidelines to ensure we establish a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Also, I may interrupt the hearing if we get out of order or become counterproductive to keep us on track and to create a clean and efficient hearing record, which is part of my role as lead administrative law judge. Are there any any questions about any of that before we go on the record? I'll begin with appellant.
I'm all good. Thanks.
All right, thank you. And Franchise Tax Board, any questions before we go on the record?
No questions, thank you.
All right, with that, I see our panel members are ready. We are going to go on the record. This is the appeal of Chernick, OTA case number 230312894. The date is May 2nd, 2025, and the time is 2:42 p.m. This hearing is being held electronically with the agreement of the parties. I am Judge Long. I will be the lead judge for the purpose of conducting this hearing. Judge Vasig was previously assigned as lead judge for this panel, but cannot attend the hearing due to unforeseen circumstances. So I will be your lead judge, while Judge Kim will be replacing Judge Vasig on this panel, and Judge Ralston remains on the panel. The panel has read the evidence briefs submitted in this appeal and are prepared to hear your case. I want to confirm whether there are any objections to this replacement. As a reminder, objections can only be for cause, such as if a judge previously worked on this case. And with that, I will ask appellant, do you have any objection to this replacement?
No.
Thank you. Franchise Tax Board.
No objections, thank you.
All right, with that, I am going to ask the parties to please identify themselves and who they represent, beginning with Franchise Tax Board.
Arthi Ramalingam and Topher Tuttle for the Franchise Tax Board.
And appellant.
Noel Chernick for myself.
All right, thank you. As stated in the minutes and orders which were issued in this case, the issue to be decided in this appeal is whether appellant, that's Mr. Chernick, has established reasonable cause to support abatement of the late payment penalty. During the pre-hearing conference, neither party raised objection to the other party's submitted exhibits. Therefore, pursuant to the minutes and orders, appellant's exhibits 1 through 5 were admitted into evidence, and FTB's exhibits A through K were admitted into evidence. After the pre-hearing conference, Mr. Chernick submitted 2 more documents. There is an April 10/25 IRS letter. On April 10th of 25, there was an IRS letter submitted that is dated March 21st of 2025. It is 4 pages long. And there is a January 25th of 2024 letter to Franchise Tax Board with an enclosed California Form 5805. I'm going to
There should be one more. I think I sent something that after the IRS letter, I believe I submitted another exhibit, which is
Could you tell me what it was you submitted and on what date you submitted it to the Office of Tax Appeals?
I sent it in on the 14th of April. It's probably it's the most important exhibit. And I did get a note that Andre Rios confirms receipt of the attached document.
Is it the letter dated January 25th of 2024 and your submission was 9 pages long and it included your state income tax balance due notice and the California Form
Yes.
1505?
Yeah, yeah.
All
That's it.
right, that is one of the 2 documents that I am referencing. We do have that.
Okay, great. Yeah,
All
that's
right. So my next question is going to be for Franchise Tax Board. Franchise Tax Board, did you receive these submissions?
Yes, we received them.
All right. Now I'm going to state that appellant's exhibits were submitted to OTA more than 15 days prior to today's hearing. So they were timely. So I'm going to ask Franchise Tax Board, do you have any objection to those 2 documents being admitted as exhibits in this appeal?
We do not have any objections. Thank you.
All right, with that, Mr. Chernick, I'm going to label those 2 submissions as exhibits 6 and 7, and they are admitted into evidence. For purposes of clarity, I'm going to state that the IRS letter dated March 21st of 2025, that's 4 pages long, will be exhibit 6, and the document that you just referenced, that is the January 25th of 2024 letter that you were referring to, that's going to be your exhibit 7.
okay.
With that, I'm going to move on to swearing in Mr. Chernick as a witness. I believe you indicated at the pre-hearing conference that you would like to offer testimony in this case. Is that still correct?
That's correct.
All right, I'm going to go ahead and swear you in. I'm going to ask you to please raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. With that, Mr. Chernick, you can go ahead and begin your presentation. You have 10 minutes and may begin when you're ready.
Sure. Yeah, I don't think I'll need the full 10 minutes, maybe even just a minute or two. Um, I sort of believe that this is a misunderstanding. My situation in 2022 was that I was working at a investment firm. The firm moved to close down after poor performance, and it wasn't until August that we sent notification out to our investors that we were going to be closing the firm, liquidating the portfolios. The sales of the portfolio positions occurred in September, and that triggered capital gains and additional capital gain income. All of that would be essentially technically impossible to have known previous into the year when the estimated taxes were due. And so, you know, I think that this is really sort of perfunctory, quite frankly. We liquidated the portfolio, triggered capital gains taxes, and I wound up paying whatever additional taxes were owed, and the California Franchise Tax Board uh, accused me of not paying in a timely capacity and charged me penalties and interest on something that I would not have been able to, uh, I wouldn't have been able to do because we didn't know that we were closing the firm and liquidating the portfolio. I presented this information just as I'm doing today in writing with my tax accountants to the US IRS. They wrote back and they abated all penalties and interest. And I'm just looking for the same treatment from the California Franchise Tax Board. I'm currently in Taiwan. It's 5:30 in the morning. I've been waiting since 4 a.m. I thought that this was going to start, and I was present at the deferred prep hearing that was postponed after the fires in Los Angeles. That was a few weeks ago. So I think the total matter is $7,500 or $7,700 or something of that nature. I've been a good California taxpayer. I think I just paid $187,000 to the California Franchise Tax Board for my 2024. So yeah, I don't believe that this is a crusade or should be a long drawn out battle. This is supported by the circumstances that I've just presented to the panel. That's all I have.
All right, thank you, Mr. Chernick. With that, I will ask Franchise Tax Board if you have any questions for Mr. Chernick about his testimony.
We do not have any questions. Thank you.
All right, and then I will turn to my panel members to ask if you have any questions for Mr. Chernick about his presentation or his testimony. I'll begin with Judge Ralston.
No questions, thank you.
Thank you, Judge Ralston. And Judge Kim?
No questions. Thank you.
All right, thank you. With that, I'm going to turn it over to Franchise Tax Board for your presentation. Franchise Tax Board, you have 10 minutes and you may begin whenever you're ready.
Thank you. Good afternoon. My name is Arthi Ramalingam. With me is my co-counsel, Topher Tuttle, and we represent Respondent Franchise Tax Board in this matter. The issue on appeal is whether appellant has demonstrated reasonable cause to abate the late payment penalty for the 2021 tax year. The law states that the Franchise Tax Board is required to impose a penalty for the late payment of tax when a taxpayer fails to pay the tax due on or before the due date of the tax return, unless the taxpayer establishes that the late payment was due to reasonable cause and not willful neglect. Here, appellant filed and paid his taxes for the 2021 tax year on September of 2022. A late payment penalty was imposed because of his return and payment were remitted after the April 15th deadline. When the Franchise Tax Board imposes a late payment penalty, the law presumes it was correctly imposed. The taxpayer has the burden of proof to demonstrate reasonable cause exists for abating the penalty. In the appeal of Triple Crown Baseball, the OTA held that reasonable cause requires a showing that the taxpayer acted with ordinary business care and prudence, or as an ordinarily intelligent and prudent business person would have acted under similar circumstances. Inability to pay may be considered reasonable cause. However, it is the taxpayer's burden to show an inability to pay. This would require a complete financial picture, including both income and expenses at the time payment fell due. Here, appellant argues that he was unable to pay his taxes for the 2021 tax year because he incurred significant expenses associated with his divorce. In this case, appellant has not provided enough evidence demonstrating his financial condition on the payment due date. Without evidence of appellant's total expenditures and available assets, appellant has failed to meet his burden of proof to establish that he was unable to pay the total tax owed on the due date. Although the Franchise Tax Board is sympathetic to the appellant's stated financial constraints, appellant appears to have earned income greater than his stated expenses. Furthermore, the documents provided do not demonstrate his full financial condition when payment was due. In summary, the late payment penalty was properly imposed because appellant failed to pay the total tax owed by the April 15th deadline for the 2021 tax year. Moreover, appellant has failed to demonstrate reasonable cause to abate the late payment penalty because he has not substantiated his inability to pay. Accordingly, appellant has not established reasonable cause to abate the late payment penalty in this appeal, and the Franchise Tax Board respectfully requests that its action be sustained. Thank you, and I'm happy to answer any questions the panel may have.
All right, thank you. With that, I'm going to turn it over to my panel members for questions. Judge Ralston, do you have any questions for Franchise Tax Board or Mr. Chernick?
No questions at this time, thank you.
Judge Kim?
I guess my question is for Mr. Chernick. It looks like the tax year at issue here is 2021, and your arguments or your testimony was kind of in regards to tax year 2022. Do you have anything specific for the 2021 tax year?
I believe that this is for 2022. I have really no idea what the OTA is discussing. I've reviewed this a dozen times with my tax attorneys. So I believe that, yeah, I have, I mean, this is exactly the same matter that was dealt with the US IRS. It is for a matter that was through the year of 2022. That's what we're dealing with.
Okay, thank you.
Thanks.
All right, I'm just going to look here at my records. Franchise Tax Board, I'm looking at the claim for refund denial in this case, and I want to confirm the claim for refund denial is concerning tax year 2021. Is that correct?
That's correct. 2021 is the tax year at issue. Thank you.
All right. And then I'm going to ask Mr. Chernick, I am looking at the letter you submitted from the Internal Revenue Service. And it looks to me that it is referencing tax year ending in December 31st of 2022. Is that correct?
Correct, yeah.
All right, thank you. That is going to be all of my questions. With that, Mr. Chernick, would you like to make a final statement or a rebuttal of Franchise Tax Board's presentation? I can give you 5 minutes to do that if you'd like.
Yeah, I don't believe that we've made a mistake. I've reviewed this. I've paid thousands of dollars already to my tax accountants, and the matter is pertinent to the fact that I couldn't have paid my 2022 taxes in a timely capacity because of decisions that were made through the 2022 tax year. And yeah, I mean, we made it. I'm just repeating myself, so nothing further to add.
All right, thank you, Mr. Chernick. I'm going to ask my panel if we have any final questions. Judge Ralston?
No questions, thank
All right, Judge Kim?
No further questions. Thank you.
All right, with that, this case is submitted on May 22nd of 2025, and the record is now closed. I want to thank everyone for participating today. The judges will meet to deliberate and decide your case. We will issue a written opinion within 100 days. Today's hearing in the appeal of Chernick is now concluded. This hearing is adjourned, and that concludes our hearing calendar for today. Thank you.
Thank you.
Thank you.